You'll be out of this house by next Friday, the woman said as if she were reminding me about trash pickup. She stood on the front steps of my $34 million lakefront estate wearing a navy blazer with an HOA badge clipped to the lapel, one hand resting on a leather folder, the other pointing casually toward the driveway. The board has already agreed. This property belongs with people who actually belong in this community. The morning air smelled faintly of fresh-cut grass drifting up from the shoreline below. Sunlight reflected off the water behind me, turning the surface of the lake into a sheet of silver. I looked at her for a moment. Then I said one word. No. She blinked as though she wasn't used to hearing it. Excuse me. Her tone sharpened instantly. You clearly don't understand how things work here. A black SUV sat at the curb behind her. Another woman was inside taking notes on a tablet. They had arrived less than 15 minutes after I pulled into the driveway with the last of my moving boxes. Patricia Whitmore, president of the Lakecrest Preserve HOA, had not introduced herself. She had not welcomed me to the neighborhood. She had walked directly to my front door and informed me that I needed to leave my own property. You are standing on my land, I replied. Patricia actually laughed. Not because she thought I was joking, because she genuinely believed I was wrong. That house behind me wasn't just another luxury property. It wasn't an investment. It wasn't a vacation home. My grandfather had first walked that shoreline in 1958 carrying a tackle box and a rolled survey map under his arm. My father learned to fish from the old cedar dock that still stretched into the lake. My mother spent summers painting sunsets from the West Terrace. Even after she passed away, her paintings remained hanging in the library upstairs. Every room held a memory. Every stone path carried part of my family's history. 3 generations had poured pieces of their lives into that estate long before it ever carried a multi-million-dollar price tag. The last box I had carried inside that morning sat unopened near the foyer. It was small, faded, and reinforced with brittle brown tape. Most people would have mistaken it for junk. Inside were old property records, county surveys, handwritten correspondence, and an original deed copy my grandfather kept for decades. I almost left the box in storage. Something told me not to. Patricia glanced past me toward the front hall. I'm giving you an opportunity to leave voluntarily before this becomes embarrassing. Her confidence never wavered. She spoke like ownership was a technicality and authority belonged to whoever claimed it loud enough. I looked at the lake, then back at her. I'm not leaving. The smile disappeared from her face. Then we're going to have a problem. At that moment, I had no idea how far she was willing to go to take something that was never hers. But standing there on the front steps of my family's estate, watching her act as though generations of history meant nothing, I knew one thing for certain. Patricia Whitmore had just made the biggest mistake of her life. Patricia Whitmore opened the leather folder and removed 3 sheets of paper with the kind of ceremony usually reserved for court orders. This is a preliminary compliance notice, she said. The board has determined that your occupancy status requires review under our community asset protection guidelines. I glanced at the papers without taking them. Which article gives you that authority? Her smile tightened. Authority is derived from the board's responsibility to preserve community standards. Show me where that is written. She tapped the top page with a manicured finger. The board operates under established governance procedures. It was not an answer. It was a cloud of words designed to sound important. Behind her, the woman in the SUV stepped out carrying a tablet and began taking photographs of the house. The front entrance, the driveway, my moving truck. Patricia noticed me watching. Documentation is part of the compliance process. For what violation? I asked. Occupancy irregularities. What irregularities? Those are currently under review. Another non-answer. I finally accepted the papers and skimmed the first page. The document was full of phrases like community reallocation review, resident verification protocol, and board authority assessment. It looked official until you actually read it. Then it became obvious that none of it identified a specific violation. No statute, no covenant number, no article reference. Just language. Lots of language. Which section of the governing documents allows community reallocation? I asked. Patricia folded her arms. You are focusing on technicalities. Property ownership is a technicality? The woman with the tablet stopped typing for a second. Patricia ignored the question. The board has reason to believe this residence was improperly transferred. Based on what? Internal records. Which records? Board records. Can I see them? Those records are confidential. That answer arrived much faster than the others. I looked down at the notice again. Near the bottom was a reference to a pending board review scheduled for the following week. The language suggested that my right to remain on the property was somehow subject to board approval. That caught my attention immediately. You believe the board can decide whether I am allowed to stay in a house I legally own? Patricia nodded without hesitation. The board has broad authority regarding community membership. Community membership and property ownership are not the same thing. They are closely connected. Show me where that is written. For the first time, she looked irritated. Not angry. Irritated. Like a teacher being questioned by a student she thought should already know his place. Mr. Holloway, cooperation would make this process much easier. For whom? She did not answer. Instead, she handed me another document labeled Resident Status Verification Request. It required signatures, financial disclosures, employment information, and authorization for additional review. What happens if I decline? I asked. The board may proceed under non-compliance procedures. Which article authorizes that? Silence. The woman with the tablet suddenly looked away. Patricia reached for her folder and closed it with a sharp snap. You will receive further communication from the board. Then she turned and walked toward the SUV. As she opened the passenger door, a folded paper slipped partially from the side pocket of her folder. For only a second, I saw the heading. Property Ownership Summary. Beneath it was a name. Not mine. Not the previous owner either. Whoever the board thought owned this estate, they were working from information that was already wrong. And if their entire case was built on that mistake, Patricia Whitmore had just revealed far more than she intended. The moment Patricia Whitmore's SUV disappeared down the road, I stopped thinking about arguments and started thinking about records. People lie. Paperwork usually does not. I carried the old family archive box into the library and set it on the same oak desk my grandfather had used for nearly 30 years. The cardboard was faded, the corners worn soft from decades of storage. Inside were property surveys, correspondence, tax records, title reports, and dozens of documents most people would have thrown away long ago. My grandfather never threw away anything connected to the estate. He used to say that land remembers everything, but only if someone keeps the records. I opened a fresh black notebook and wrote the date across the top of the first page. Then I created an evidence log. Time, event, document, observation. It was a habit I learned during years of business acquisitions. When facts matter, memory is not enough. I recorded Patricia's visit, the compliance notice, the photographs taken by her assistant, and every statement she had made about board authority. After that, I logged into the county property records database. Within 20 minutes, I found the parcel record for the estate. Parcel number 17-442-08A. Owner of record, Grant Holloway. The transfer had been recorded 6 weeks earlier. Everything looked exactly as it should. I saved screenshots, printed copies, and noted the timestamps in my notebook. Then I searched the adjacent records. That was where something strange appeared. According to a board document Patricia had accidentally revealed, someone else was listed as the owner. Yet every county record showed otherwise. That discrepancy should not have existed. Either the board was using outdated information, or someone had created an entirely separate ownership file. Neither possibility made sense. I requested additional public documents and downloaded the most recent parcel map. That map revealed another detail. A narrow strip of land connecting the estate entrance to the main road was highlighted differently from surrounding parcels. At first glance, it looked insignificant. Just a small access corridor. But when I checked the legend, it was identified as a private easement tied directly to the original estate deed. I sat back in my chair. That easement had existed since 1958, the same year my grandfather purchased the property. Yet several recent HOA maps available through community documents showed the entrance road as a community-managed access route. Community-managed, not privately controlled. I compared the maps side by side. Same road, same location, different legal descriptions. My pencil stopped moving. There it was again. Another inconsistency. Not proof of wrongdoing. Not yet, but enough to make me uncomfortable. I pulled the original survey from the archive box. The paper crackled softly as it unfolded across the desk. Survey stamps, county signatures, legal descriptions. Everything matched the public records I had just downloaded. My grandfather had even written notes in the margins decades earlier. Looking at his handwriting felt like hearing his voice again. This was not just property. It was family history preserved in ink. I photographed every page, organized digital folders, and created backup copies. Then I added a new entry to the evidence log. Multiple ownership inconsistencies. Easement description conflict. Source documents secured. As evening approached, one realization became impossible to ignore. Patricia Whitmore had arrived at my front door completely confident. Too confident. The kind of confidence people have when they believe their paperwork supports them. The problem was that the paperwork I could verify was telling a very different story. The next morning, I received a phone call from someone I had never met. "Mr. Holloway," a calm voice asked. "My name is Daniel Mercer. I used to serve on the Lakecrest Preserve Architectural Review Committee. I think you should see something." 30 minutes later, Daniel arrived carrying 2 thick binders and a banker's box filled with folders. He did not bring opinions. He brought documents. That immediately got my attention. We sat at the library table while he carefully arranged everything in front of me. Parcel summaries, board meeting minutes, compliance notices, property review reports. Most were copies he had retained during his years working with the association. "I resigned 18 months ago," he said. "At first I thought it was incompetence. Then I started noticing patterns." He opened the first binder. Every page was tabbed and dated. Daniel pointed to a spreadsheet containing dozens of property addresses. Several had yellow highlights next to ownership fields. Others contained handwritten notes. "Look at the dates." I did. The pattern appeared almost immediately. Homeowners would purchase property. A few months later, internal HOA records would begin showing different classifications, different access descriptions, or different ownership annotations than those appearing in county records. "How many?" I asked. "At least 14 that I personally found." 14. That was not a clerical mistake. Daniel slid another folder across the table. Inside were certified mail receipts from multiple residents. Every homeowner had received some version of a compliance notice, ownership review, community asset evaluation, or resident verification demand. Different wording. Same result. Pressure. Delay. Confusion. I opened my notebook and started logging every document. Folder number. Source. Date. Supporting evidence. Then Daniel handed me something even more concerning. A stack of parcel maps. The same neighborhoods. The same roads. The same lots. But not the same legal descriptions. Certain easements appeared differently depending on which version you reviewed. In some cases, private access routes were labeled as community-managed corridors. In others, ownership references had been replaced with administrative classifications that did not appear anywhere in county filings. "Who created these?" I asked. Daniel shook his head. "That is what I could never figure out." I compared 3 maps side by side. The discrepancies were impossible to ignore. More importantly, they were consistent. The same types of changes appeared again and again. Different homeowners. Same modifications. Different parcels. Same outcome. Every change seemed to increase HOA influence while reducing the visibility of private ownership rights. Daniel then opened the banker's box and pulled out a final folder. "This is why I contacted you." Inside were letters from residents. Real people. Retired couples. Families. Property owners who had spent years fighting administrative disputes they did not understand. One homeowner spent 8 months correcting an ownership classification error. Another had to hire a surveyor after an HOA map contradicted a recorded easement. A third discovered board records describing part of his private waterfront as a community access area despite county records showing otherwise. None of them had lost their property, but every one of them had been forced into expensive, exhausting disputes. I added another entry to the evidence log. Multiple affected homeowners. Repeated document inconsistencies. Consistent administrative pattern. Potential systemic issue. Daniel leaned back in his chair. "When Patricia came after your estate, people noticed. A lot of us have been comparing notes." I looked at the growing pile of documents covering the table. Hours earlier, I thought I was dealing with one HOA president who refused to accept that I own my own home. Now there were 14 documented cases. Multiple parcel discrepancies. Altered classifications. Repeated compliance campaigns. This was no longer a disagreement between Patricia Whitmore and me. Whatever was happening inside Lakecrest Preserve had been happening for years. And for the first time, I began to suspect that my family's estate was not the target. It was simply the biggest property they had ever tried to bring under their control. Daniel returned the following afternoon with another folder. This one was thinner than the others, but the expression on his face told me it mattered more. I could never prove anything, he said as he placed it on the table. But I think I finally found what connects everything. Inside were business registration records, corporate filings, property acquisition summaries, and meeting agendas obtained through public records requests. The first name that appeared repeatedly was Harbor Crest Development Group, LLC. The second was Blue Meridian Investment Fund. Neither company appeared anywhere in HOA newsletters, community updates, or board communications. Yet both names surfaced repeatedly in documents connected to parcels surrounding Lakecrest Preserve. I opened my notebook and started a new section. Corporate connections. Evidence source. Public filing reference. Daniel pointed to a series of acquisition records. Over the previous 4 years, Harbor Crest Development Group had quietly purchased multiple properties bordering the community. Small purchases at first. A marina parcel, a maintenance lot, an undeveloped shoreline tract. Then larger acquisitions followed. Every purchase seemed unrelated until the parcels were placed on a map together. That was when the pattern became visible. The acquisitions formed a nearly continuous corridor surrounding the lake. Nearly, but not completely. One property interrupted the chain. Mine. I stared at the map for several seconds. My estate occupied the exact section connecting the northern shoreline to the private access corridor near the main entrance. Without it, the assembled land holdings remained fragmented. With it, everything connected into a single continuous development footprint. Daniel slid another document toward me. It was a planning memorandum prepared by a consulting firm. Several sections had been redacted, but one sentence remained visible. Strategic continuity requires acquisition or control of remaining connector parcels. I circled the phrase immediately. Connector parcels. My estate sat at the top of the list. Another attachment contained preliminary concept drawings. Private residences were replaced by luxury villas. Expanded marina facilities appeared along the waterfront. New retail structures occupied areas currently protected by existing easements. The estimated project value exceeded $300 million. Suddenly, Patricia's behavior made sense. This had never been about community standards. It had never been about occupancy reviews or compliance notices. Those were tools, pressure mechanisms, administrative leverage. The real objective was acquisition. Daniel opened the final folder. You need to see this one. Inside were meeting attendance records from HOA board sessions. Patricia Whitmore's name appeared repeatedly. So did another name. Jonathan Kessler, Managing Director. Harbor Crest Development Group, LLC. Not a homeowner. Not a board member. Yet he had attended multiple closed-door meetings over the previous 2 years. Meeting after meeting. Month after month. I compared dates. The timing aligned almost perfectly with the ownership disputes affecting other residents. The same residents who received unusual compliance notices. The same residents whose parcel descriptions had somehow become distorted inside internal HOA records. I added another entry to the evidence log. Potential coordination between HOA leadership and outside development interests. Supporting documentation secured. Then I noticed something even more troubling. Several homeowners involved in previous disputes owned parcels located directly along the proposed expansion corridor. Every single one. Not random targets. Strategic targets. Patricia Whitmore was not acting alone. She was not even the architect of the plan. She was simply the local authority figure capable of creating enough pressure to make certain owners sell, surrender, or become exhausted. For days I had believed I was fighting an HOA president determined to control my property. Now the documents told a different story. The HOA was only the visible layer. Behind it stood developers, investment money, acquisition strategies, and a project worth hundreds of millions of dollars. And according to the map spread across my desk, my family's estate was the one parcel they absolutely could not build without. Once I understood what I was dealing with, I stopped collecting documents alone. I started building a professional record. The first call went to Rebecca Sloan, a land use attorney who had spent 20 years handling easement disputes, development conflicts, and property rights cases. The second went to a licensed surveyor named Thomas Keene. The third went to the county clerk's office. Within a week, My dining table looked less like a home and more like a records archive. Certified copies of deeds, recorded easements, parcel maps, meeting minutes, corporate filings, survey certifications. Every document was scanned, indexed, and logged. Rebecca insisted on one rule. Do not argue with them publicly. Let them create evidence. That advice turned out to be invaluable. 3 days later, the Lakecrest Preserve Community Facebook group exploded with rumors. Someone posted that I was attempting to block future community improvements. Another claimed I was involved in an ownership dispute with the county. A third suggested that the property transfer itself was under investigation. None of it was true. What caught my attention was how quickly the story spread. Screenshots appeared in my evidence folder within minutes. Timestamp, username, post content, comment chain. Everything was preserved. Then came the HOA meeting announcement. Special board session. Community asset review. My property address appeared directly in the agenda summary. Daniel sent me a copy before it was publicly distributed. I added it to the evidence log. The following evening, several neighbors I had never met began approaching me with cautious questions. Had I really violated community rules? Was it true the board was reviewing my ownership status? Had I ignored compliance notices? I answered politely but briefly. Then I documented each conversation afterward. The pattern was obvious. Someone wanted the neighborhood talking. Someone wanted pressure. Rebecca called it a reputation campaign. If they cannot move the paperwork fast enough, she said, they move public opinion. Meanwhile, Thomas completed a fresh survey of the estate. Every boundary marker matched the historical records. Every easement matched the county filings. Everything was exactly where it should have been. For 48 hours. Then something strange happened. 2 survey stakes near the northern access corridor were no longer where Thomas had placed them. Not far. Just enough to matter. I photographed the original survey images. Then I photographed the current position. Timestamped. Logged. Thomas returned and confirmed the stakes had been moved. He documented it himself. Another folder entered the archive. Another piece of evidence. 2 days later, an unsigned letter appeared in my mailbox. No return address. No signature. Just a single sentence typed across the page. You should consider selling before this becomes expensive. I placed the letter in a protective sleeve and scanned it immediately. Rebecca smiled when she saw it. Good, she said. They are getting nervous. The pressure continued. More Facebook posts. More rumors. More community speculation. Yet something interesting was happening beneath the surface. Every new attack generated another document. Every accusation created another timestamp. Every act of pressure strengthened the record we were building. The evidence archive had grown from a single notebook into 6 organized binders and a secure digital database. By the end of the month, we had ownership records, survey certifications, corporate filings, HOA communications, witness statements, screenshots, certified mail receipts, and documented examples of interference. For the first time since Patricia Whitmore knocked on my door, I felt the balance shifting. They still believed they were controlling the narrative. They still believed they were pushing me toward surrender. What they did not realize was that every move they made was quietly strengthening the case that would eventually be placed in front of people far more powerful than an HOA board. The first visible crack in their system appeared 3 nights before the special HOA meeting. Rebecca called me at 8:17 p.m. and told me to come to her office immediately. When I arrived, another woman was already sitting across the conference table. Mid-50s. Nervous. Exhausted. She introduced herself as Linda Carver. For 11 years, she had served as recording secretary for the HOA board. Then she slid a cardboard archive box across the table. I made copies, she said quietly. Everything. Inside were printed emails, board correspondence, financial summaries, executive session minutes, invoice approvals, and internal memoranda. Not rumors. Not opinions. Documents. Real documents. Rebecca opened the first folder. Within minutes, neither of us was speaking. One email chain from nearly 2 years earlier contained correspondence between Patricia Whitmore and Jonathan Kessler from Harbor Crest Development Group, LLC. The subject line read Strategic Parcel Acquisition Priorities. Attached was a color-coded map. My estate sat at the top of the list. The date stopped me cold. It was 14 months before I had even purchased the property. 14 months. Patricia had been discussing control of my family's estate before she knew who the future owner would be. Linda handed over another folder. Meeting minutes. Official minutes had never mentioned my property. The unedited internal drafts did. Entire paragraphs had been removed before publication. One line was highlighted. Connector parcel remains highest priority. Community compliance measures should continue until ownership alignment is achieved. Ownership alignment. Not compliance. Not community standards. Ownership. Another document contained budget approvals, legal consultation expenses, property review expenses, administrative enforcement initiatives. Nearly every expenditure traced back to parcels located along Harbor Crest's proposed development corridor. Then Linda produced what Rebecca immediately called the smoking gun. A printed email exchange. Patricia Whitmore. Jonathan Kessler. 2 attorneys. 1 accounting consultant. The message included a simple sentence. Without the HOA parcel, the entire project fails. I read it twice. Then a third time. There it was. Everything reduced to 1 sentence. My family's estate was not an inconvenience. It was the missing piece. The one property preventing a $300 million development from becoming reality. Linda was not finished. She opened a final folder containing board correspondence dating back years. Homeowners who later received compliance notices had first appeared on internal watch lists months beforehand. Their parcels were evaluated. Their ownership histories reviewed. Their willingness to sell discussed privately. The disputes came later. The targeting came first. That realization changed everything. None of the previous conflicts had been accidental. They had been planned, sequenced, managed. Patricia's knock on my front door was merely the final stage of a process that had already been operating behind closed doors for years. The next morning, I made the first public move. At the entrance to the estate, beside the original stone monument my grandfather commissioned decades earlier, Thomas Keene installed certified survey markers and recorded ownership verification placards tied directly to county records. Every marker referenced recorded deed numbers, parcel numbers, and easement documents. Large, visible, impossible to misunderstand. By noon, residents were stopping to look. By afternoon, photographs were spreading through neighborhood social media. For the first time, people could see physical proof with their own eyes. Not rumors, not accusations. Recorded ownership, certified surveys, county documentation. Patricia spent months controlling the narrative. One afternoon of visible evidence started tearing it apart. But what mattered most was sitting inside Rebecca's office. The archive box, the emails, the minutes, the financial records. Because now I knew something Patricia never intended anyone to discover. Long before she demanded that I leave my own property, she had already been planning how to take it. The special HOA meeting was scheduled for 7 o'clock on a Thursday evening. Patricia Whitmore clearly expected a public victory. Residents filled the room. Board members sat behind their usual table. What Patricia did not expect was who arrived before the meeting began. Rebecca Sloan entered carrying 3 binders. Behind her came Daniel Mercer and Linda Carver. 10 minutes later, a county records supervisor took a seat near the back wall. Then 2 local reporters arrived. Finally, a deputy from the sheriff's office stepped inside and quietly positioned himself near the entrance. The room immediately changed. Patricia noticed it too. She kept glancing toward the growing audience while pretending not to. At exactly 7 o'clock, she opened the meeting and announced that the board would address ongoing compliance concerns regarding my property. She had barely finished the sentence when Rebecca stood up. Before any discussion begins, she said, we would like several documents entered into the public record. Patricia objected immediately. Rebecca handed copies directly to every board member. Certified county deeds, easement records, survey certifications, ownership confirmations. Then came the internal emails, the meeting minutes, the development correspondence. The room grew quieter with every page turned. Patricia attempted to move to another agenda item. The county records supervisor stood and confirmed that the ownership documents were authentic and currently recorded. A reporter asked why internal HOA records contradicted county records. Patricia had no answer. Then came the moment everyone remembered. Earlier that afternoon, Thomas Keene and his survey team had completed installation of permanent deed reference markers along the private access corridor leading to my estate. Each marker displayed the recorded parcel number, deed reference, and ownership designation verified by county records. At the entrance itself stood a newly installed steel gate bearing a simple sign, Private Property. Access subject to recorded easement terms. County file reference displayed below. Nothing dramatic. Nothing emotional. Just law. Visible. Permanent. Easy to understand. The reporters had already photographed it. Several residents had seen it before arriving. Patricia tried to claim the road remained subject to HOA authority. Rebecca responded by projecting a certified easement map onto a screen at the front of the room. Every line matched the markers now standing outside. Every reference matched county records. Every ownership claim Patricia had repeated for weeks collapsed in front of witnesses. Then the smoking gun email was introduced. Without the Holloway parcel, the entire project fails. The words appeared on the screen behind the board table. Nobody needed an explanation. Residents stared at Patricia. Board members stared at Patricia. Even Jonathan Kessler's name appeared in the correspondence trail. Suddenly, the compliance notices, ownership reviews, and community asset language looked very different. They looked like part of a plan. Patricia attempted to speak several times. Each attempt ended with another document, another record, another email, another certified filing. By the end of the meeting, the deputy sheriff had not intervened once because there was nothing to intervene in. No argument, no confrontation, just paperwork, verified records, public evidence. Patricia Whitmore had spent years using documents to pressure other people. Now documents were dismantling everything she had built. And as residents left the meeting carrying copies of the evidence, it became obvious that the collapse everyone had witnessed was larger than a single HOA president. The entire system behind her was starting to come apart. The aftermath moved faster than anyone expected. Within 3 weeks, the county formally confirmed every ownership record tied to my estate. Certified deed copies were reissued. Survey certifications were entered into the public record. Easement documentation was reaffirmed. Every question Patricia Whitmore had raised was answered by the same thing that had protected the property for decades: recorded facts. The estate belonged to me. It always had. The access corridor belonged exactly where the deed said it belonged. The easements remained exactly as the survey described them. There was no ambiguity left. But the consequences did not stop with my property. State investigators began reviewing communication between Harbor Crest Development Group LLC and multiple entities connected to the proposed project. Blue Meridian Investment Fund suddenly postponed several acquisitions. The development proposal that had quietly advanced for years was suspended pending review. Several pending transactions were canceled entirely. The HOA board itself fractured almost immediately. 2 members resigned within days. Others publicly claimed they had never seen many of the internal documents revealed during the meeting. A special election was scheduled. Patricia Whitmore was removed from her position before the end of the quarter. What surprised me most was what happened to the other homeowners. The people whose files had been buried in folders and forgotten in archives finally started receiving answers. Corrected parcel records. Verified easement confirmations. Withdrawn compliance disputes. One retired couple recovered access rights that had been questioned for nearly a year. Another homeowner received formal acknowledgement that his waterfront boundary had been incorrectly classified in HOA records. One by one, the people who had spent years fighting administrative confusion finally saw those issues resolved. The evidence had done more than protect one estate. It had exposed a system. Several months later, I carried the original archive box back into the library. The same box my grandfather had packed decades earlier. The same box that nearly stayed in storage. Inside were the surveys, maps, deeds, and handwritten notes that had preserved the truth long before any investigation began. I added one final document to the collection: a certified county ownership confirmation bearing the current seal and recording number. Then I placed it beside my grandfather's original survey from 1958. For a long moment, I simply sat there looking at both documents together. One created nearly 70 years earlier. One created only weeks ago. Different generations. Same property. Same family history. That was when I finally understood something Patricia Whitmore never did. The estate was never valuable because it was worth $34 million. It was valuable because every generation had protected it long enough to pass it forward. Money could measure the property. It could not measure what the property meant. I thought the story ended there. Then, 6 days later, a certified envelope arrived with no return address. Inside was a single photocopied survey page. Across the bottom margin, someone had circled a parcel number I had never seen before. Attached to it was a handwritten note containing only a set of GPS coordinates and one unfamiliar name: Blackthorn Land Holdings, LLC.